Hello everyone. Today I am going to talk about the prevention of oppression and mismanagement. The objectives of this lecture are to understand the meaning of the terms oppression and mismanagement, to discuss the prevention of oppression and mismanagement under the Companies Act 2013, to understand how an application can be made to the tribunal against such oppression and mismanagement, and who can file such application, and to get an idea about class action. The terms oppression and mismanagement are not defined under the Companies Act 2013. These terms are to be interpreted by the court depending upon the facts of each case. The simple meaning of oppression is that it is an unjust or cruel exercise of authority or power. It can also be defined as an act or instance of oppressing, the state of being oppressed and the feeling of being heavily burdened mentally or physically by troubles, adverse conditions and anxiety. In the Black Law Dictionary, the term oppression is defined as the act or an instance of unjustly exercising power. In the case of Dale and Carrington Investment Private Limited versus P.K. Prathapan, it was held that increasing the capital of a company with the sole purpose of gaining control over can be termed as oppression. Mismanagement, on the other hand, means conducting affairs in some prejudicial, dishonest or inept manner. When the affairs of the company are being conducted in a manner prejudicial to the interests of the company or its members or against the public interest, it amounts to mismanagement. Mismanagement refers to practices of managing the company incompetently and dishonestly. Violation of Memorandum of Association, Articles of Association or other statutory provisions would amount to mismanagement. In the case of Elder versus Watson Limited, the term oppression was defined. Oppression refers to a misdemeanor committed by majority shareholders upon the minority shareholders of the company. Chapter 16 of the Companies Act 2013 deals with the prevention of oppression and mismanagement. The majority rule is normally followed in the company and thereby courts do not interfere to protect minority rights. However, prevention of oppression and mismanagement is an exception to the rule. Earlier under the Companies Act 1956, Section 397 dealt with the application against oppression and mismanagement. The Companies Act 2013 lays down the provision to make an application against the oppression under Section 241. The Chapter 16 of the Companies Act clearly specifies who can raise a complaint and under which circumstances a complaint may be raised of oppression and mismanagement. This chapter contains 6 sections from sections 241 to 246. For the prevention of oppression and mismanagement, a person must apply to the tribunal. According to section 241, any member of a company who complains that the affairs of the company have been or are being conducted in a manner prejudicial to the public interest or in a manner prejudicial or oppressive to him or any other member or members or in a manner prejudicial to the interests of the company, or the material change not being a change brought about by or in the interests of any creditors, including debenture holders or any class of shareholders of the company, has taken place in the management or control of the company, whether by an alteration in the board of directors or manager or in the ownership of the company's shares, or if it has no share capital in its membership or in any other manner whatsoever, and that by reason of such change it is likely that the affairs of the company will be conducted in a manner prejudicial to its interests or its members or any class of members may apply to the tribunal, provided such member has a right to apply under section 244 for an order under this chapter. The central government, if it is of the opinion that the affairs of the company are being conducted in a manner prejudicial to the public interest, it may itself apply to the tribunal for an order under this chapter. Section 242 talks about the powers of the tribunal. It says, if on any application made under Section 241, the tribunal is of the opinion that the company's affairs have been or are being conducted in a manner prejudicial or oppressive to any member or members, or prejudicial to public interest, or in a manner prejudicial to the interests of the company, and that to wind up the company would unfairly prejudice such member or members, but that otherwise the facts would justify the making of a winding up order, on the ground that it was just and equitable that the company should be wound up. The tribunal may, with a view to bringing to an end the matters complained of, make such order as it thinks fit. Without prejudice to the generality of the powers under subsection 1, an order under that subsection may provide for the regulation of conduct of affairs of the company in future, the purchase of shares or interests of any members of the company by other members thereof or by the company. In the case of a purchase of its shares by the company, the consequent reduction of its share capital, restrictions on the transfer or allotment of the shares of the company, the termination, setting aside or modification of any agreement howsoever arrived at between the company and the managing director, any other director or manager, upon such terms and conditions as may, in the opinion of the tribunal, be just and equitable in the circumstances of the case. The termination, setting aside or modification of any agreement between the company and any person other than those referred to in clause E, provided that no agreement shall be terminated, set aside or modified except after due notice and after obtaining the consent of the party concerned. The setting aside of any transfer, delivery of goods, payment, execution or other act relating to property made or done by or against the company within 3 months before the date of the application under this section, which would, if made or done by or against an individual, be deemed in his insolvency to be a fraudulent preference. Removal of the managing director, manager or any of the directors of the company. Recovery of undue gains made by any managing director, manager or director during the period of his appointment as such, and the manner of utilization of the recovery, including transfer to Investor Education and Protection Fund or repayment to identifiable victims. The manner in which the managing director or manager of the company may be appointed subsequent to an order removing the existing managing director or manager of the company made under clause H. Appointment of such number of persons as directors who may be required by the tribunal to report to the tribunal on such matters as the tribunal may direct. Imposition of costs as may be deemed fit by the tribunal. Any other matter for which, in the opinion of the tribunal, it is just and equitable that provision should be made. A certified copy of the order of the tribunal under subsection 1 shall be filed by the company with the registrar within 30 days of the order of the tribunal. The tribunal may, on the application of any party to the proceeding, make any interim order which it thinks fit for regulating the conduct of the company's affairs upon such terms and conditions as appear it to be just and equitable. Where an order of the tribunal under subsection 1 makes any alteration in the memorandum of articles of a company, then, notwithstanding any other provision of this Act, the company shall not have power except to the extent, if any, permitted in the order to make, without the leave of the tribunal, any alteration whatsoever which is inconsistent with the order, either in the memorandum or in the articles. Subject to the provisions of subsection 1, the alterations made by the order in the memorandum or articles of a company shall, in all respects, have the same effect as if they had been duly made by the company in accordance with the provisions of this Act, and the said provisions shall apply accordingly to the memorandum or articles so altered. A certified copy of every order altering or giving leave to alter a company's memorandum or articles shall within 30 days after the making thereof be filed by the company with the registrar, who shall register the same. If a company contravenes the provisions of subsection 5, the company shall be punishable with fine which shall not be less than 1 lakh rupees but which may extend to 25 lakh rupees. And every officer of the company who is in default shall be punishable with imprisonment for a term which may extend to 6 months, or with fine which shall not be less than 25,000 rupees but which may extend to 1 lakh rupees, or both. Section 243 talks about the consequences of termination or modification of certain agreements. It says, where an order made under Section 242 terminates, sets aside or modifies an agreement such as is referred to in subsection 2 of that section, such order shall not give rise to any claims whatever against the company by any person for damages or for compensation for loss of office or in any other respect, either in pursuance of the agreement or otherwise. No managing director or other director or manager whose agreement is so terminated or set aside shall, for a period of 5 years from the date of the order terminating or setting aside the agreement, without the leave of the tribunal, be appointed or act as the managing director or other director or manager of the company, provided that the tribunal shall not grant leave under this clause unless notice of the intention to apply for leave has been served on the central government and that government has been given a reasonable opportunity of being heard in the matter. Any person who knowingly acts as a managing director or other director or manager of a company in contravention of clause B of subsection 1 and every other director of the company who is knowingly a party to such contravention shall be punishable with imprisonment for a term which may extend to 6 months, or with fine which may extend to 5 lakh rupees, or both. Section 244 says that the following members of a company shall have the right to apply under Section 241, namely, in the case of a company having a share capital not less than 100 members of the company or not less than 1/10 of the total number of its members, whichever is less, or any member or members holding not less than 1/10 of the issued share capital of the company, subject to the condition that the applicant or applicants has or have paid all calls and other sums due on his or their shares. In the case of a company not having a share capital not less than 1/5 of the total number of its members, provided that the tribunal may, on an application made to it in this behalf, waive all or any of the requirements specified in clause A or clause B so as to enable the members to apply under Section 241. Where any members of a company are entitled to make an application under subsection 1, any one or more of them having obtained the consent in writing of the rest may make the application on behalf and for the benefit of all of them. The word class action is defined under Section 245 of the Company Act. A class action is where number of claimants with common grievance against the company are allowed to file a lawsuit against the company. Claimants can collectively use their resources such as share attorney's services and save their litigation costs to a great extent. The financial scale attached to the class action suit is perceived as a saving grace for individuals with limited resources. Section 245 says that such number of member or members, depositor or depositors, or any class of them as the case may be, as are indicated in subsection 2, may, if they are of the opinion that the management or conduct of the affairs of the company are being conducted in a manner prejudicial to the interests of the company or its members or depositors, file an application before the tribunal on behalf of the members or depositors for seeking all or any of the orders, namely, to restrain the company from committing an act which is ultra vires the articles of memorandum of the company, to restrain the company from committing breach of any provision of the company's memorandum of articles, to declare a resolution altering the memorandum or articles of the company as void if the resolution was passed by suppression of material facts or obtained by misstatement to the members or depositors, to restrain the company and its directors from acting on such resolution, to restrain the company from doing an act which is contrary to the provisions of this act or any other law for the time being in force, to restrain the company from taking action contrary to any resolution passed by the members, to claim damages or compensation or demand any other suitable action from or against the company or its directors for any fraudulent, unlawful or wrongful act or omission or conduct or any likely act or omission or conduct on its or their part. The auditor, including audit firm of the company, for any improper or misleading statement of particulars made in his audit report or for any fraudulent, unlawful or wrongful act or conduct, or any expert or advisor or consultant or any other person for any incorrect or misleading statement made to the company or for any fraudulent, unlawful or wrongful act or conduct or any likely act or conduct on his part, to seek any other remedy as the tribunal may deem fit. Where the members or depositors seek any damages or compensation or demand any other suitable action from or against an audit firm, the liability shall be of the firm as well as of each partner who was involved in making any improper or misleading statement of particulars in the audit report, or who acted in a fraudulent, unlawful or wrongful manner. The requisite number of members provided in subsection 1 shall be, in the case of a company having a share capital not less than 100 members of the company or not less than such percentage of the total number of its members as may be prescribed, whichever is less, or any member or members holding not less than such percentage of the issued share capital of the company as may be prescribed, subject to the condition that the applicant or applicants has or have paid all calls and other sums due on his or her their shares. In the case of a company not having a share capital not less than 1/5 of the total number of its members, the requisite number of depositors provided in subsection 1 shall not be less than 100 depositors or not less than such percentage of the total number of depositors as may be prescribed, whichever is less, or any depositor or depositors to whom the company owes such percentage of total deposits of the company as may be prescribed. In considering an application under subsection 1, the tribunal shall take into account in particular whether the member or depositor is acting in good faith in making the application for seeking an order, any evidence before it as to the involvement of any person other than directors or officers of the company on any of the matters provided in clause A to F of subsection 1, whether the cause of action is one which the member or depositor could pursue in his own right rather than through an order under this section, any evidence before it as to the views of the members or depositors of the company who have no personal interest, direct or indirect, in the matter being proceeded under this section. Where the cause of action is an act or omission that is yet to occur, whether the act or omission could be and in the circumstances would be likely to be authorized by the company before it occurs or ratified by the company after it occurs, where the cause of action is an act or omission that has already occurred, whether the act or omission could be and in the circumstances would be likely to be ratified by the company. If an application filed under subsection 1 is admitted, then the tribunal shall have regard to the following, namely, public notice shall be served on admission of the application to all the members or depositors of the class in such manner as may be prescribed. All similar applications prevalent in any jurisdiction should be consolidated into a single application, and the class members or depositors should be allowed to choose the lead applicant, and in the event the members or depositors of the class are unable to come to a consensus, the tribunal shall have the power to appoint a lead applicant who shall be in charge of the proceedings from the applicant's side. Two class action applications for the same cause of action shall not be allowed. The cost or expenses connected with the application for class action shall be defrayed by the company or any other person responsible for any oppressive act. Any order passed by the tribunal shall be binding on the company and all its members, depositors and auditor, including audit firm or expert or consultant or advisor or any other person associated with the company. Any company which fails to comply with an order passed by the tribunal under this section shall be punishable with fine, which shall not be less than 5 lakh rupees, but which may extend to 25 lakh rupees. And every officer of the company who is in default shall be punishable with the imprisonment for a term which may extend to 3 years, and with fine which shall not be less than 25,000 rupees, but which may extend to 1 lakh rupees. Where any application filed before the tribunal is found to be frivolous or vexatious, it shall, for reasons to be recorded in writing, reject the application and make an order that the applicant shall pay the opposite party such cost not exceeding 1 lakh rupees as may be specified in the order. Nothing contained in this section shall apply to a banking company. Subject to the compliance of this section, an application may be filed or any other action may be taken under this section by any person, group of persons or any association of persons representing the persons affected by any act or omission specified in subsection 1. To conclude, the recent collapses of large companies and corporations globally has made such entities to carefully ponder over their actions towards affairs of the company. Accountability has increased by the tool of class action suits that are filed against the management personnel regarding their deeds of oppression and mismanagement. The individual shareholder of the company and the minority shareholders have been empowered to take up action against the unjustified abuse of power and authority by the managerial personnel under the law regarding oppression and mismanagement. An individual may file an application before the tribunal informing about the oppression and mismanagement carried out by any key personnel against him or any other shareholder of the company. So this was all about today's lecture. Hope you have understood the lecture. Thank you for watching.